All right, we can get started now. Thank you, everyone, for joining us for this Georgetown Federalist Society event, Religious Liberty in 2020. We got a lot of cases that we're going to talk about today, an amazing guest. So before we get started, I'm Dalton. I'm a junior in the college majoring in government and psychology, and I'll be moderating tonight's discussion. I'm super pumped, not only to talk about religious liberty, but to do so with someone that I greatly admire personally. So I first met our guest today, Erin Hawley, working for her husband, Senator Josh Hawley, back in my home state of Missouri. Her credentials are impeccable, so I'll go through those a bit now. Miss Erin Hawley is of counsel to the appellate practice of Kirkland and Ellis, LLP. She's a former associate professor of law at the University of Missouri School of Law and senior fellow to the Kinder Institute for Constitutional Democracy and a senior legal fellow for the Independent Women's Law Center. Yeah, her credentials are impeccable. She's one of the smartest people that I've ever got the privilege to talk about these issues with. So we're super excited to have her here tonight. Erin, you can introduce yourself a little bit.
Great. Well, thanks so much for having me. I'm excited to talk to you about one of my favorite topics, religious liberty. And especially excited to be here with Dalton. As Dalton said, we met several years ago. And some of you may know this, but he has younger brothers and sisters. Which was really great because we have two very wild boys that Dalton helped with and do in addition to doing lots more important things. So delighted to be here with you. Especially I love that Dalton and the rest of you are engaging with these issues at this point in your careers. I know Dalton is interested in law school and many of you may be as well. So I'd love to encourage you in that pursuit. Especially if you're interested in religious liberty issues. As we'll discuss, there are many percolating through the lower federal courts and the Supreme Court, even as we speak.
So tonight, basically the way it's going to work, Erin is going to have a brief introduction for 5 to 10 minutes, kind of give us a background of where religious liberty issues are standing in 2020, kind of the most recent cases, some really important debates that are happening in litigation. And then we're going to go into about 20-25 minutes of questions that the board has prepared for her, things that we think are really interesting that you guys might enjoy. And then after that, we're going to have audience questions. So I'll put this in the chat as well, kind of once Erin gets talking, just to remind people. But the Q&A section at the bottom of your tab, you can use that to submit questions, and we'll flip through them and choose some really good ones to ask Erin. We'll also use those to help give out the Grubhub gift cards that we have for attending tonight that we have. Usually we have food at our events, but since we can't meet in person, we'll use the questions to kind of give out some of those. And also, we want to remind everyone before we get started that the views expressed here are only those of the individual speaking them, don't represent any of the organizations that are a part of this. And obviously anything dumb that I say, don't pin that on Erin. But yeah, so we're super excited for tonight. And just to kick us off, Erin, if you want to kind of give a little background and just kind of your introduction, a little monologue for 10 minutes or so, and then we'll launch into questions.
Sure, absolutely. So to begin, as I mentioned, there really has not been a more exciting time to be interested in religious liberty or to be a religious liberty litigator than the past term, as referred to as October term 2019, and this coming Supreme Court term, October term 2020. And I think the reasons for this are several-fold. But we'll discuss in detail many of the Supreme Court cases from last year. But just to give a brief overview, the court had at least 4 major religious liberty cases on its docket in 2019 through 2020, which is really unheard of. So a huge blockbuster term for religious liberty. A couple of those cases, which we'll discuss, are Bostock versus Clay County, which involves SOGI protections under Title VII and how that applied to the statute. There was a case also with the court this past term called Lady of Guadalupe. We won't probably get into this as much in questions, though I'm happy to answer them. But in Lady of Guadalupe, the question was really a simple one, and that is under the Free Exercise Clause, ministers of churches and synagogues and those types of things are allowed to sort of dictate their own internal governance. And that includes deciding, who to hire as a minister. They can have certain restrictions on who can serve as their clergy in different churches and in different religious organizations. And the question presented in that case was how far that went The specifics involved 2 Catholic schools, and the teachers at issue were not religious teachers per se, but they did serve as religious leaders. They incorporated prayer into their classrooms. They taught from a biblical worldview. They viewed their mission and ministry not only to educate children, but to do so within the sort of lens of the Catholic faith. So in this case, the Ninth Circuit decided that actually you had to have the title of minister in order to qualify for this ministerial exception and for internal church governance to govern rather than sort of outside regulations. And the Supreme Court, in a lopsided decision, actually 7-2, said no, that internal church governance includes people that sort of serve their churches, serve church schools by including religious instruction, and they don't have to have the formal title. So here we see a pretty lopsided decision in favor of religious liberty, and pretty sensible one. We want churches to be able to maintain their own internal governance without a lot of interference from the state. We'll also talk at length about a decision called June Medical. This was a Louisiana case in which Louisiana had passed a statute that regulated abortion clinics and required abortion providing doctors to have admitting privileges at nearby hospitals. That case came out 5-4 in favor of striking down the Louisiana statute, and we'll talk about that. Also before the court was a case called Trump versus Pennsylvania. And you guys may be more familiar with this in the context of the Little Sisters of the Poor. The Little Sisters of the Poor have been up and back before the Supreme Court no less than 3 times in the last 10 years. Almost a little bit of relief. And the Supreme Court said that the Trump administration was entitled to grant them a religious liberty exemption from the contraceptive mandate. So big cases from the 2019 term. Coming up in 2020, I would love for you to pay attention to several cases. On November 4th, a case called Fulton versus City of Philadelphia will be argued. And this case presents a challenge to a case we'll also talk about, Smith versus Employment Division. And so a major sort of upheaval might happen in religious liberty in early November. The case also concerns the question of what happens when a city conditions foster services on agreement with certain non-discrimination provisions. So in that case, Catholic Social Services provides foster care. The City of Philadelphia forbid them from doing so unless they sign a non-discrimination provision, which the Catholic Services believe violated their religious beliefs. So the question is whether the city can hold them to that and disallow them from participating. So huge questions percolating through the courts. That's just the Supreme Court, lots of them in the lower courts as well. But I'm really excited to get into sort of the nitty-gritty details of these cases. And Dalton and the board have some great questions. And I also want to hear questions from all of you as an audience as well. So I'll turn it back over to Dalton.
Yeah, the first question that we kind of want to talk about is the one you just mentioned, the Little Sisters of the Poor and their involvement just being dragged back to the court again and again. And the most recent case builds on the decision in Burwell versus Hobby Lobby, which I know Josh was sort of involved in as well, which allowed for some exemptions of contraceptive coverage from the ACA and all that. Both of these cases rely on the free exercise clause, and we were wondering, how would you define the coverage of the free exercise clause, and what are some of the greatest misconceptions of that coverage, and kind of how does it apply to these cases?
So that's a fabulous question. And the free exercise clause has gone through a lot of iterations in Supreme Court precedent. And one thing I should mention at the sort of outset was that a number of litigators sort of thought that the Supreme Court should decide the Little Sisters case, the Trump versus Pennsylvania case, under the free exercise clause. But the court decision itself was actually more narrow. The court looked at the question of whether the Trump administration was permitted under the terms of the Affordable Care Act to grant exemptions. So it was really sort of just a statutory interpretation case. And the court said yes, that the Affordable Care Act allowed Health and Human Services to designate the sorts of things that needed to be included in women's preventive care in insurance. That included contraception. It also gave them the power to exempt religious entities like the Little Sisters from that sort of mandate. So it's actually a statutory holding, just saying the Trump administration was authorized to do this. A number of amici and the Little Sisters as well argued that the court should go further and that they should hold that either a federal statute known as RFRA, which we'll talk about, or the Free Exercise Clause itself compelled this result. The court didn't go that far. It didn't need to. It said the statute allowed it. But if we see a change in administration, if we see a cutback on the exemption for the Little Sisters, then they still have the RFRA arguments and the free exercise arguments in their back pocket. And so to talk just briefly about sort of the background of the Free Exercise Clause, it of course provides that Congress shall make no law prohibiting the free exercise thereof religion. And so the Free Exercise Clause is generally understood to include the ability to hold religious beliefs. So it's clear that the government cannot interfere with your own religious beliefs. It can't tell you to believe a certain thing. It can't mandate a particular religious opinion. It can't force you to say something that's in conflict with your religious beliefs. Where things get really tricky, however, is when it comes to religious practices and sort of the sorts of things that one's religion might compel you to do. Anything from praying to certain Native American Indian beliefs involve the use of peyote, things like that. So the real sort of conflict that you can sometimes see is between state or federal regulations, for example, drug regulations, and certain practices like the use of peyote in religious ceremonies. So when it comes to practices, the court's standards have shifted over time. In a 1963 case called Sherbert versus Verner, the Supreme Court subjected any sort of regulation that impinged on free exercise to what's known as strict scrutiny. And strict scrutiny simply means that the government has to have a compelling interest. So they have to have a really important interest, and they have to show that it's the least restrictive means available to accomplish its objectives. So for example, to get back to the Little Sisters case, the government sort of didn't argue the fact that providing contraceptives was a compelling interest. But what they did, the Little Sisters and a lot of other less restrictive, the federal government could provide it. So the argument was that the burden was not at all the least restrictive. So they had a pretty strong argument under that. Now things changed with a case called Employment Division versus Smith. And the really interesting thing about this opinion, it was that it is written by the late Justice Scalia. And Justice Scalia is generally considered to be very favorable proponent of religious liberty. But what he said in this case was that a state prohibition on the use of peyote, like we talked about, was okay, was permissible because it was a neutral law of general applicability. So the idea is if you have a criminal law, like the law criminalizing the use of peyote, that applied generally, it didn't single out any sort of religious belief, then that doesn't implicate the Free Exercise Clause, and you don't get into the sort of strict scrutiny land that existed prior to Smith. So Division versus Smith, if it is, then it probably survives. But then, sort of the twist, Congress steps in 1993 and basically reinstitutes the strict scrutiny test in a statute called the Religious Freedom and Restoration Act. So that was the other act that the Little Sisters relied upon in Trump versus Pennsylvania. And under that statute, as under a prior Supreme Court law, the city has to prove it has a compelling interest and also that it's the least restrictive means of advancing that interest. So a difficult test to meet, which provides sort of a broad scope for Free Exercise Clause review. And then the last thing I'll mention here is that on November 4th, in that Fulton case that we talked about, one of the questions presented is pretty direct, and it's whether Employment Division versus Smith should be overruled or revisited. And this will be an opportunity. A number of the Supreme Court justices have expressed disagreement with Smith. They've said it's inconsistent with the Free Exercise Clause, which should employ strict scrutiny whenever government burdens religious exercise. So it'll be really interesting to see how much the justices are interested in this argument at oral argument, and also whether it is the case that they actually address this. It may depend somewhat on the composition of the court, which I think we'll talk about later as well. But it would be huge news on the religious liberty front if Smith was overruled. So that's sort of Free Exercise Clause in a nutshell. It's pretty complicated, but a really dynamic area of the law, and one where we may see even more change in this upcoming term.
Yeah, we'll certainly get to talking about the implications of the most recent Supreme Court nominee soon. Before we get there, the next kind of issue, we actually just had an audience question come in that's kind of related to the next question I wanted to ask. But the case of Espinoza versus Montana, it's a big case, and you might have to correct me on a little bit of this if I don't get it exactly right. Interestingly, it was argued right before the COVID outbreak happened, but it basically allows for certain use of public funds for religious schools, given that the provisions preventing their funding were based solely on the school's religious status, something along those lines. And so now that the COVID-19 pandemic has hit us, and here we are on Zoom, many families have moved their kids to private schools, often religious in nature, and some people have even received funding to do that. So where do you see this specific issue of religious liberty standing at the moment, and where did the future debates about school funding kind of come about?
That's a really great question, especially you say in the context of the COVID pandemic. As you mentioned, many public schools are only operating online and remotely. Smaller private schools are often allowed to have in-person classes depending on the state and county in which they reside. So you have seen an uptick both in homeschooling and homeschooling curriculum, and also attendance at private schools. And the case you're referring to, Espinoza versus Montana, really speaks directly into those sorts of circumstances and how the state and counties and federal government can regulate private religious schools. And an issue in that case, in the Espinoza versus Montana, was a really modest tax credit program. So the Montana legislature passed a program that gave residents up to $150 in tax credit for donations to private scholarships. So just $150, not a huge donation. And then parents could apply for these scholarships for their children and use the scholarships at private schools, including religious schools. Well, then the Montana Department of Revenue, as well as the Montana Supreme Court, had held that those scholarships could not be used at religious schools, which is pretty aggressive. And what they were saying is that you can use them at any private school except those which are religious. And the reason that Montana did this is they have what's known as a Blaine Amendment, named after Senator James Blaine from Maine. It was passed in the 1800s, and they prohibit either direct or indirect use of taxpayer funds, of state taxpayer funds, to religious entities. And this involves this sort of crazy, it's called the tension or the difference between the Establishment Clause and the Free Exercise Clause. So the Establishment Clause, of course, says that government can't establish religion. So if the state of Missouri couldn't declare that the state is a Methodist state, and that the religion of Missouri is Methodist. On the other hand, we've got the Free Exercise Clause that we just talked about, and this case sort of sits at the play in the joints. And what Montana was saying was that because of our Blaine Amendment, we are going to erect a higher than necessary wall between church and state. So even though it's perfectly permissible, we know that vouchers, federal vouchers, state vouchers, can be used at private religious schools. The court held that in a case called Zellman versus Harris. So there's no Establishment Clause problem. There's no constitutional problem with you taking a voucher that you get from the state and using it as But what Montana was saying here was, even if that's true, even if you can use a voucher at a private religious school under the federal constitution, as a matter of state constitutional law, under the Constitution, we want to erect a higher wall separating church and state. And the Supreme Court, in a 5-4 opinion written by Chief Justice Roberts, really said no. It's relied on a case actually from Missouri, Trinity Lutheran. And that case, as well as the Montana case, basically say that you can't discriminate in the provision of a public program simply because an entity is religious. So in Trinity Lutheran, a religious preschool had applied to receive playground funding or funding for its playground to put in rubber mulch, so just to keep kids safe. And they had been denied this funding because they were religious. And the court said that's impermissible, that's discriminating based on religion, and is not okay under the The same result for the Montana program. It should apply both to private religious and non-religious schools, and Montana couldn't foreclose religious schools from that benefit. So after that, we know that in 30-some states. After this most recent case in Espinoza, those amendments will be rendered pretty much toothless. The Supreme Court did strike them down as being unconstitutional, but it made very clear that if a state is going to provide some sort of program, then religious entities need to be included on equal footing and cannot be discriminated against. And then you'd mentioned sort of what might be coming down the pike. I think what we'll probably see after we know in Espinoza that the Blaine amendments really can't be used to bar public funds from going to religious schools as long as they go to other schools. So states can, of course, choose not to fund private schools at all. But if they choose to fund private schools, then they can't exclude religious schools from that funding. I think you'll see schools, there's an example of a school in Maryland, and the county withdrew public funding because the Maryland school is called Bethel Academy, wouldn't agree to certain non-discrimination provisions based on sort of the traditional view of husband and wife, those sorts of things. And so I think that's probably where you're going to see a shift in this sort of litigation. Are these sorts of non-discrimination clauses, are they neutral and generally applicable against religious schools? So that's sort of, I think, coming up in a number of different cases.
Yeah, weird kind of small world thing, actually. I went to Trinity Lutheran Preschool, which is crazy, the big Supreme Court case.
That's really fun.
I know, I went there as a preschooler, so kind of funny. Only for 1 year, but yeah, pretty funny. When I first heard that was a Supreme Court case about that, I was like, no way. But yeah, crazy stuff. The next question.
And they won.
Yeah, I know. Yeah, really important. I guess I played on the chips that they won to that case. I'm not sure, but related to that, and this is, we've gotten 2 questions already in the Q&A about this, and so it's very similarly related. But I have a question, kind of, again, sort of from my own personal experience, that we're gonna sort of tie to the last question. So we're on this, socially distanced Zoom right now, and obviously that's this is the current, situation. So pandemic law and religious liberty, how do those things connect? So as you're aware, my church actually out here in DC, Capitol Hill Baptist, recently received an injunction from the DC Circuit in their suit against Mayor Bowser's COVID-19 restriction that prevented church meetings. So the injunction basically allows them to meet. And I think an interesting quote from that Judge Trevor McFadden, who I know the quote he used goes like this: "While the law may take periodic naps during a pandemic, we will not let it sleep through one." So as a religious liberty lawyer, how do you balance saving lives and public health considerations with the serious threats to religious liberty that arise during public health crises?
That's a really great question, Dalton. And I think one that the courts around the country and the Supreme Court have been struggling with. I agree wholeheartedly with Judge McFadden. There is a Supreme Court case law that talks about how you sort of balance exigencies, public health emergencies with the Constitution. And one really interesting case that the Supreme Court is a case called Calvary Chapel. And Calvary Chapel is out in Nevada. They're a church, and under Nevada regulations, they were not allowed to admit more than 50 persons, no matter the building capacity, no matter what sort of safety measures employed. But interestingly enough, being in the city of Las Vegas did rallies or those sorts of things. And in fact, you could have a casino operating at 50% capacity with thousands of people in the same building, and yet churches were restricted to a strict 50-person limit. Understanding is that churches in DC were limited to 100 persons, including outdoor services. So you couldn't have over, even if you were outside, even if you were socially distanced, even if you wore masks. But on the other hand, the mayor's office and city government had facilitated different forms of expression, different protests, those sorts of things. And Capitol Hill Baptist argued that these are both important forms of free First Amendment expression. You've got the ability to peacefully protest, protected by the First Amendment, but you also have the right to assemble and to freely worship, protected by the First Amendment. And I think Judge McFadden was correct to look at that and say that to hold different standards discriminates against freedom of religion. And there's and Justice Alito in that Calvary Chapel case says that a public health emergency doesn't give officials carte blanche to disregard the Constitution for as long as the medical problem persists. So he had argued that, you know, when a pandemic is starting out, you don't know what's happening, when you don't know much about the science, then maybe courts should sort of defer to officials and to allow them to craft policies to respond to health emergencies. But at some point, they're required to craft regulations and policies that account for constitutional rights. And we really see this even in a case from 1866. And this involved events at the height of the Civil War. So very dramatic events, very crucial in our nation's history. And certain states had suspended the right of habeas corpus. And the Constitution can't be modified in times of crisis. It said that the founding charter applies at all times and under all circumstances, and they couldn't think of anything more pernicious than that any of its provisions can be suspended during any of the great exigencies of government. So I really think we get sort of a situation where courts will look fairly deferentially at sort of regulations, policies that are implemented right at the outset as cities and states struggle to sort of figure out what to do. But courts should also be very clear that there's not an exception to the Constitution, and they might be able to take naps, as Judge McFadden said, but they can't sleep through it. So I foresee that we'll see further court orders saying states and cities may have gone too far in certain circumstances.
So we were talking a little earlier, this question's a little late now, it was submitted through the Q&A, but I just like it so much that I think we should talk about it now, about the Establishment Clause. And so one guest says, oh, and you're gonna understand, I guess you can read it on your Q&A if you open the Q&A thing. You're gonna understand this a whole lot better than I am able to, but the second question about Justice Thomas's view of the Establishment Clause, saying that there should be a sort of federalism prevention, that actually the Establishment Clause shouldn't be incorporated against individual states, but should only be like a federal government. Kind of where do you, can you explain that a little bit more than I guess than I can? And then where do you see that issue lying? And, you know, do you think that's correct?
Sure. So that's a great question. And as your questioner asks here or suggests, Justice Thomas does have a different view of the Establishment Clause. So in Justice Thomas's views, as he expresses in a number of concurrences in different cases, is that the Establishment Clause should only apply to the federal government, and that states should actually be more free to do certain things than the federal government. And there's this sort of broad incorporation debate that applies to all of really the Bill of Rights. So the Bill of Rights itself, by its terms, only applies to the federal government. So the First Amendment, its entirety, the Free Speech Clause, the Freedom of Free Exercise Clause, all of those things originally applied just to the federal government. The court, through time, through the 14th Amendment, has done something called incorporation. So they've incorporated all of those rights, so they also apply to state governments. And Justice Thomas argues that I think he probably has a dim view of incorporation in general, that may not be the intent of the 14th Amendment. But he would also argue that the Establishment Clause in particular gives states and localities a lot more freedom and really just the federal government. I doubt that that argument will get much play. I can see possibly Justice Gorsuch supporting him, although I don't believe he has in any of the recent cases from last term. So there's a possibility you could get 2 or 3 justices expressing that view, but I don't think the court itself will go back on incorporation of the Establishment Clause. So great question. Yeah,
really good question. So another kind of heated recent case, probably the biggest one of this cycle, I would say, Bostock versus Clayton County, where the Supreme Court was asked, to consider whether an employer who fires an individual for being gay or transgender violates Title VII of the Civil Rights Act of 1964. And so now Congress, has proposed several times, but not yet passed, amendments to extend the protection to these individuals under the act. But in Bostock, the court ruled that an employer does in fact violate the act when he or she fires someone for being gay or transgender. Do you see any issues with this decision? Is it in any jeopardy in the future, particularly if the Supreme Court shifts with the confirmation of Amy Coney Barrett? Where do you see, is this still in jeopardy, or is it a done deal now? And are there any flaws in the logic there?
So yeah, great question. And Bostock versus Clayton County, probably one of the biggest, if not the biggest case from this past term, was a surprising decision in that the decision ended up being 6-3. The decision was written by Justice Gorsuch, who's sort of a self-proclaimed textualist. It was also joined by Chief Justice Roberts, as well as the 4, so-called liberal justices: Justice Ginsburg, the late Justice Ginsburg, Justice Sotomayor, Justice Kagan, and Justice Breyer. So sort of a different lineup there than many people expected. And to talk first about, I think, the problems with the decision, I think there's 2 main ones, or 2 major problems. And the first one is the one you referenced in your question, and that's that the decision really short-circuits the democratic process. So even if one agrees with the court's results, the decision stopped the legislative process. It stopped those debates in the states. It stopped the debates in Congress. And related to that, I think that if you look at Title VII and you look at Justice Gorsuch's opinion, even though it's clothed in textualist garb, that majority opinion really adopts an interpretation of Title VII that no one would have anticipated when the statute was passed in 1964. So in my opinion, at least, Justice Gorsuch really to say something that no one would have intended in 1964. And the whole point of textualism is that the words that Congress writes matter, as we want our judges to pay attention to those words, and we want them to employ sort of the plain or everyday meaning of those statutes, precisely so that those of us who are governed by them know what's expected. And so Justice Gorsuch admits that in 1964, when Title VII was passed, that it wouldn't have been known that Title VII extended these sorts of protections as well. But nevertheless, he finds that the plain meaning of the statute can sort of trump that everyday understanding and can. I really like Justice Alito's reminder in his dissent. He quotes Justice Scalia, and he says that statutory terms should mean what they convey to reasonable people at the time they were written. So that would have been the text that I would have advocated for in Bostock. And again, that's not to say anything about the underlying policies, simply to say that the elected representatives are the ones who should be enacting those policies, not 9 justices of the Supreme Court.
Yeah, so we have a couple questions left on the board, and then we'll move into more Q&A from the audience. The next case that's kind of on our agenda is June Medical, which is the most recent abortion case that came before the Supreme Court, in which the Supreme Court, as you mentioned earlier, ruled that a Louisiana state law placing a hospital admission requirement on abortion clinics was unconstitutional. So the court heavily relied on past abortion precedent, particularly the undue burden standard. We actually had a discussion on Planned Parenthood versus Casey specifically 2 weeks ago with this club, so fresh on our minds. So can you bridge the gap for us between Roe, Casey, Whole Women's Health, June Medical, all of these kind of abortion cases, and specifically how the most recent case leaves the abortion issue up to future discussion, especially with a new court possibly, and then how it builds on the past cases?
So yeah, absolutely. So as you guys likely learned from your discussion of Casey, the Casey was a revision of sorts to Roe versus Wade. So in Roe versus Wade, the Supreme Court created the constitutional right to have an abortion, was established in that case in Roe versus Wade. But then that was in 1973. And that decision in Roe really just subjected, it had sort of a trimester system, but it subjected any sort of regulation or state statute that would limit a woman's right to choose. It would, anything that limited those would be subject really to something like strict scrutiny. And that, again, we talked about is pretty hard. So legislation concerning abortion was analyzed really, really toughly it was held to a high standard. Under Roe versus Wade. Planned Parenthood versus Casey was decided in 1992. And while it upheld I call it the essential right of Roe versus Wade, of a woman's right to choose, it modified the test and it created what's called the undue for abortion restrictions. And the plurality opinion there was written by Justice O'Connor, Justice Kennedy, and Justice Souter. And they basically said that the due process clause of the 14th Amendment protects a woman's right to choose, but return to strict scrutiny and replace it with a new burden standard. So then we go through sort of several decades where the court was working out how to apply Casey's undue burden standard. And then we get a couple of years ago called Whole Women's Health. And Whole Women's Health involved a Texas law that was quite similar to the Louisiana law that Dalton was talking about. And in Whole Women's Health, what the Texas legislature had done was said that in order to protect women's health, any clinics, any abortion doctors that are providing abortion have admitting privileges at a nearby hospital in case something goes wrong. Well, it turns out that a lot of these doctors don't have these sorts of admitting privileges. And so the doctors and the clinics sued Texas, arguing that this imposed an undue burden on women's rights as affirmed in Roe and Casey. And so the Supreme Court, again, a couple of years ago, so you had Justice Kennedy on the court, a different court than today. The Supreme Court 5-4 struck down the Texas law under Casey's standard. And so the court said that the Texas law imposed an undue burden. Interestingly and importantly, Chief Justice Roberts dissented in that case pretty vociferously. And one of the things he said in that case, that the majority was improperly applying the Casey framework, and that Casey simply required both a legitimate purpose by the state, but assuming that was met, then it just asked whether there was a substantial burden on the woman. And the Chief Justice Roberts accused the majority of really sort of doing a balancing standard rather than looking just at standard. So then we get, and he'll flesh this out more in the next case we'll talk about, which is June Medical. And in June Medical, which was decided just last term, at the very end of the term, we get another. And as I just mentioned, Chief Justice Roberts had Whole Women's Health, and then we have a change in the composition of the court. We now have Justice Gorsuch, who has replaced Justice Kennedy. So there was a lot of speculation that maybe June Medical would come out differently than did Whole Woman's Health. It didn't. Spoiler alert, the Chief Justice signed a concurrence with the 4 more liberal members, I should say, members of the Justice Ginsburg, Sotomayor, Kagan, Breyer, and the Chief Justice joined in a decision that struck down the Louisiana law. But they did it on very different grounds. The plurality looked at the benefits of the law in Louisiana and said it really didn't benefit women's health, these admitting privileges. And they said it's a very real burden on a woman's right to choose, as upheld in Casey. The Chief Justice says something quite differently. He basically said that you can't separate the Texas law from the Louisiana law. And my own personal opinion, this is just my opinion, I don't have inside knowledge on this, but it seems to me that the chief was sort of upset with the Fifth Circuit. So the Fifth Circuit decided both the Whole Woman's Health and June Medical. And the chief's basic view is like you can't differentiate between those 2 statutes. They're really pretty identical. And so it should have followed Supreme Court precedent and struck down the Louisiana law in June Medical. So that's my sort of guess as to why the chief came out the way he did, an opposite way from his decision in Whole Woman's Health. So in June Medical, he relies on stare decisis and says you can't distinguish these 2 laws. They're the same. Under Supreme Court precedent, the Louisiana law has to fall. But he also says something really interesting. He says that the plurality has gotten the law wrong. And you can't strike down an abortion regulation just because the court thinks that it's not super beneficial in comparison to the burden. You find instead that there's a substantial burden on the right outlined in Casey. And just last Friday, we get a decision out of the Sixth Circuit. And the Sixth Circuit is a case called EMW Women's Surgical Center versus Planned Parenthood. And in that case, a district court had enjoined, so they had struck down a Kentucky law that required abortion facilities to have ambulance and transport agreements with local hospitals. And the Sixth Circuit overturned that. They upheld the Kentucky law, and they looked at Chief Justice Roberts' concurrence, and they said it's not enough that a court might think the balance, that there's not a lot of good that comes from the statute in terms of women's health. It's enough to find that there's not a substantial burden. And in this case, the Sixth Circuit found that there's not a substantial burden. So they looked at Chief Justice Roberts' opinion in Whole Woman's Health and how it sort of narrowed the scope of review in June Medical, and how it narrowed the scope of review under Whole Woman's Health. And so we are seeing a trend in the courts of appeals that even though June Medical decided against states' right to sort of regulate abortion procedures, that other states' regulations may be upheld under the chief's opinion. So complicated set of facts, complicated set of sort of changing standards, but we are seeing different courts of appeals sort of pare back on their own review and give more leeway and deference to states in being able to regulate abortion clinics and the like.
Mm-hmm. So our last board question is about the Amy Coney Barrett nomination. So I think we might actually save that for the end because we have one really great audience question that I want to get to from Noah Blake Smith. You can find it in the question and answer. I think it's the bottom one. But he asks about what we were talking about earlier. How does the Bostock decision square with the religious liberty of churches, synagogues, et cetera, and with the closely held religious beliefs of private companies? So can I guess maybe taking it away from the government a little bit, how do you think those issues square, and just kind of explain that issue a little bit more?
Absolutely, and that's a fabulous question, and something that the court will be forced to deal with given its holding in Bostock. As the question suggests, the Bostock decision sort of sets different groups on a collision course with Title VII because it includes within the anti-discrimination provisions, transgender and other protections. And you have different groups. If we think of Arlene's Flowers, who refused as sort of a creative exercise to provide flowers for same-sex marriages. And so you really get this potential for a huge sort of tension, a huge conflict to arise between religious believers and this new holding of the Supreme Court that Title VII extends so broadly. So the court's going to have to sort that out. And the dissent pointed this out, and Justice Gorsuch does deal with it in his Bostock opinion. My guess is that the court will need to grapple with it under the free exercise clause. And so you're going to get the sort of things that you got, for example, in the Masterpiece Cake Shop. So that was a case that came up, I think, 2, maybe 3 years ago. And in that case, you had a Colorado baker who refused to bake a cake for a same-sex wedding. They took him all the way to the Supreme Court. He had been fined by the Colorado Human Rights Commission. And the Supreme Court struck down that fine and that sort of penalty from the Human Rights Division. And they found that the commission was sort of had been motivated by religious animus. But they didn't really lay out a clear way to proceed on how to balance non-discriminatory provisions with the clear free exercise clause and freedom of religion. So that's something the court will need to grapple with. My hope is that they will carve out religious liberty protections and provide that sort of free autonomy space that churches and religious believers are supposed to have under the free exercise clause. But that's something that, of course, we'll have to deal with.
Yeah, so another question, getting to the Amy Coney Barrett nomination a little bit before we do more generally, this question's a little more specific. During her initial confirmation hearing, some senators showed a hostility toward her religious beliefs. Would you say that the constitutional provision prescribing religious texts for public office is under threat in this current situation, or do you think it's not quite to that level yet? I know you wrote a case about, or you wrote an article about this, so.
So absolutely. So I think it's quite serious. And actually, if you look back to her 2017 hearings, this was when Judge Barrett was nominated to the Seventh Circuit. And the religious bias was even more apparent in those hearings. This is where Senator Dianne Feinstein had said, the dogma lives loudly in you. And Senator Hirono had asked, can you actually be a judge? You're a Catholic, and can you separate those two things? So it's pretty clear in the most recent hearings and also in the 2017 hearings that the senators were pressing Judge Barrett on her ability to separate her Catholic faith from her duties as a judge. And as she explained quite ably, that she's perfectly able to do that, perfectly capable of separating those two things. But their continued suggestion that she wouldn't be able to do that as a faithful Catholic, I think, does give rise to sort of the concerns about a religious test that we see the Constitution forbidding.
Yeah, it's fascinating. I guess we'll get to our question on the nomination a little bit more now, just because I think it's so interesting. I'm very interested to hear what you have to say. So just filling Ruth Bader Ginsburg's seat with Amy Coney Barrett, obviously a huge shift ideologically, any way you slice it. Much of what we've discussed tonight is kind of the future of religious liberty battles. But what are those battles, and which way will they fall if she is confirmed and the court shifts that much? Not only in terms of how cases are decided, but even what cases are brought before the court. What do you or what is at stake for religious liberty in this current nomination process, and how much will the court really shift, in your opinion, if Amy Coney Barrett is confirmed?
So those are fabulous questions, and we can only sort of guess from her answers and her previous writings. But to one of the points that you made, whereas of course a majority opinion on the Supreme Court takes 5 votes, it only takes 4 votes in order to grant cert. So I do think that it will make a difference in the sorts of issues that the Supreme Court takes upon itself to decide. As your listeners probably know, the court is almost entirely a court of discretionary review. So you have to apply for the Supreme Court review in the certiorari process, and only about 1% of cases are granted, so a very slim percentage. But one justice can have a huge difference in the cert process. And I would expect Judge Barrett to be sort of cognizant if she becomes a justice of religious liberty issues and deciding them. So I think that will make a difference, as you said, in the cases the court hears. Also, I think if you look closely Judge Barrett's hearings, there are a couple of differences between what she said regarding religious liberty and what the Chief Justice or even Justice Alito said regarding religious liberty. And the question in particular I'm thinking about is she was asked about Griswold versus Connecticut. And Griswold was the case that came prior to Roe, and Griswold upheld the right of a marital couple to have contraception and said that that couldn't be criminalized under Connecticut law. And both Chief Justice Roberts and Justice Alito had basically suggested in their confirmation hearings that that was settled law. And as Judge Barrett said in her hearings, I don't think that anyone's contraceptive rights, right to contraceptives are all at issue, that's not going to happen. But it was interesting that she didn't say that case was settled law or rightly decided. She really seemed to leave herself a lot of room to sort of deal with substantive due process on its own terms. And as even Justice Ginsburg and many liberal scholars have recognized, the sort of constitutional doctrine that underlies Roe versus Wade is really shaky. So the idea that we have these sort of penumbras and emanations that come out of all these different amendments doesn't really sort of comport with the idea of how the Constitution should be interpreted. So I think that you will see Justice Barrett being suspicious of substantive due process. And that, of course, substantive due process includes things like Lochner and cases where even more conservative legislators tried to impose different economic regulations and those sorts of things. So you've got the economic substantive due process as well as sort of the Roe versus Wade line of cases. So I expect that she'll be suspicious of substantive due process in general, given her sort of and textualism views. As far as other cases go and how that'll come out, as she said in the hearings, she believes in stare decisis. So she's not going to just take a hatchet through various Supreme Court opinions. But of course, stare decisis is not absolute, and there are instances in which cases can be overturned by a later Supreme Court. A couple of areas I think she might have a lot of immediate impact are the pandemic cases. For whatever reason, the Calvary Chapel case we talked about earlier, the Supreme Court actually denied an injunction in that case. But you had 4 dissents. You had Justice Kavanaugh, Gorsuch, Alito, and Thomas, all of who dissented quite vociferously and said that this is crazy, that casinos can be open at half capacity and churches are limited to 50 people. Judge Barrett probably to be in that camp. So you might see some additional protection for religious liberty when you're talking about COVID restrictions. So I think she'll be hopefully a voice of reason in that as well. So it's exciting to think about where our religious liberty might go, where the court might go, and those sorts of things.
Yeah, I would agree. I would expect if she is Justice Barrett to be in that camp, largely maybe just because her family might even violate some of the COVID violations alone of some of these states. So who knows? So yeah, definitely probably in that camp. We'll do one last question and we'll wrap up around 9. This one's interesting. This one it's a little more philosophical maybe than what we've gone over before. It's the most recent question suggested in the Q&A. It says, what is the role of honor in the office of Chief Justice? And you clerked for Justice Roberts. So I think you might have a little bit more insight than the average person. How do you think Justice Roberts has done in maintaining the impartiality of the court? And what's the role of honor, in a Chief Justice?
That's a really great question, and something people will probably write many a book upon. So Chief Justice Roberts, something that is widely known is that one of his heroes, probably his sort of top judicial hero, is Chief Justice Marshall. And Chief Justice Marshall had a couple of things that were really important to him. One was unanimity. At that point in time, the justices rode circuit and they didn't have a permanent home in DC, so they all stayed in the courting house. And they would actually debate these cases, over their dinner. And so that helped, I think, Chief Justice Marshall sort of marshal the troops and get opinions that had a lot of unanimity in them. So that's something the chief would like to see. Another thing that was critically important to Chief Justice Roberts really was the role of the court as an institution. Of course, in the case where we first see judicial review and sort of that recognition that the court could act as a check on the legislative and executive branches. And so the court's place in sort of the structural government was really important to Marshall. I think it's also quite important to the Chief Justice. From his confirmation hearings, he has that famous line, you know, a judge's job is to be an umpire rather than part of a team, to call balls and strikes. And so I think his view of the judiciary is one that's about politics, not enmeshed in the political battles. As he said, you know, we don't have Republican judges and Democratic judges, we have judges. And so I think that really is his view, and his desire, I think, is to see, is for the court both to be and to be perceived as outside of politics, as an independent branch, and a check on government, no matter who's in the White House or which branch controls Congress. So I think honor is quite important to the chief. And I think his sort of view of the court as an institution does influence the way he approaches cases, and perhaps even the way he decides them. I think you know, again, it's a thought experiment, so we don't know whether this is true, but I wonder if his votes in certain cases may even have been different if he were an associate justice versus his role as chief justice. I think it's quite possible that could have been a deciding, or not a deciding factor, but it could have changed the way he views his role on the court.
It's very interesting. Well, thank you, Erin, so much for joining us tonight. This was wonderful. I know I learned a whole lot, and I'm sure all of our guests did too. Is there any way or anything you want to kind of say on the way out, ways that people could reach out to you about questions, or, you know, kind of routes that they should pursue if they're interested in these kind of things, just from your perspective?
Absolutely. So you can email me. Feel free to email me. I'm at the University of Missouri. So just Hawley, HAWLEYE @missouri.edu. I would be happy to hear from you. Talk about law school or any of those sorts of things. And then also with the confirmation schedule, I think the Judiciary Committee is scheduled to vote on Judge Barrett tomorrow, on Thursday, and possibly the full Senate on Monday. And one thing that got so much play in the hearings was the Affordable Care Act. And I actually think that Judge Barrett actually said quite a lot about the Affordable Care Act. And every time that it came up, she distinguished the recent case, Texas versus California, or California versus Texas, from the two, they're consolidated, from the two prior cases. And then she also, every time the case was brought up, she mentioned severability. And she also said that she agreed with 7 justices from this term that there's a presumption of severability. So just they don't sort of buy the line that she's intent on destroying healthcare. I actually think that the chances of the court or her striking down the entire statute are quite slim.
Interesting. Yeah, but exciting couple days coming up. I'm glad we got to talk about this when all this is happening. It's great time, and well, yeah, lots of stuff happening, but super exciting. So everyone, feel free to reach out to Erin, and thank you, Erin, so much for joining us. I know it was really wonderful.
Absolutely. Thanks for having me. Take care.